to enable the investigating officer to be able to conclude the investigations in the matter, and at the same time allow the DPP an opportunity to make a decision to charge. The matter having been canvassed before your brother, Honorable Abdikadir Lorot, on the 31st day of October 2025.
That first of
October 2025.
Yes.
He issued the orders for custodial for 10 days against the suspects.
Yes.
And after the decision of your brother, a number of issues have emerged and new developments. And therefore the DPP has not been able to make a decision to charge in the matter. One of the developments that has been advanced since the ruling on 31st of October 2025.
Just a minute. Proceed to the first one.
The first development that has emerged after the ruling by your brother on 31st of October is that on 3rd of November 2025, the learned counsel for the suspect did write a letter to IPOA requesting that the matter and the investigations be
Dated
taken.
when? The letter to IPOA?
3rd of November 2025. Requesting that the matter be taken over by IPOA for purposes of investigations. And Your Honor, the said letter was well in line with the DPP's direction that all matters related to investigations touching on police officers be referred to IPOA or be taken over by IPOA.
Yes.
Subsequently, again, Your Honor, the DPP has directed that the resultant file be submitted to him personally for purposes of review and direction. Your Honor, due to this development and pursuant to the application that was made on that 1st of October 2025, the issues that led to the said application to be made before your brother, Honorable Lorot, and leading to him issuing the orders that were issued to detain the suspects for 10 days. The said issues, Your Honor, that are contained in the notice of motion and the sworn affidavit of the investigating officers are still alive. And it's on this premise that, Your Honor, we do pray before this honorable court that the court do grant the DPP 14 days extra to enable the investigations that have been or are yet to be taken over by the IPOA, pursuant to the request by the defense, and in line with the directions of the DPP with regard to matters involving police officers, active police officers. and the same reasons that were stated in the notice of motion dated 31st of October 2025 and averred to by the investigating officer in his affidavit dated the same date. We will wish to reiterate that the same witnesses that were still to be traced are still not yet been traced. And therefore, Your Honor, the state is apprehensive that if the investigating officer is not given ample time to be able to conclude these investigations, then there is very high likelihood that the ends of justice may not be achieved as envisaged. Within our laws. Of great importance is to note that the suspect before you, as this was clearly stated, both in cross-examination that was done before your honorable brother, Cherop, and in the affidavit that was averred by the investigating officer. It's important to note that the suspects are not ordinary citizens.
You have said cross-examination?
Yes, there was cross-examination that was conducted by the defense counsel of the investigating officer with relation to his affidavit before your honorable brother. The suspects are not ordinary people, and therefore they wield immense influence against the potential witnesses that the state intends to rely on in this matter. And as such, Your Honor, we pray that you do find it necessary to extend the custodial orders so issued by your brother, Honorable Cherop, for purposes of enabling the investigating officer to conclude the pendency of the investigations. That will be all. To warrant the detention of the suspects before you. Your Honor, when I started my submission before you, I said that the state that existed on the 31st of October 2025 and demised within the application dated 31st of October 2025.
And that is what the Constitution says. We do not discriminate against the political class and the rich and powerful vis-a-vis the poor people. Let them feel and enjoy the sanctity and sanctuary of judiciary. You understand, firm? Because 55 million Kenyans believe in the judiciary. Let the judiciary stand and protect these harmless young men. If you look at their faces, for 10 days, these police officers have been without liberty. Another 14 days is another dilemma. May the court find favor in my application and put the conditions as provided for in the celebrated case of Michael Oyamo in the Court of Appeal decision, where the Governor Obado, I was in that matter, Obado was
The case of?
Michael Oyamo. I can't remember the citation. It is a celebrated Court of Appeal decision where Justice Receipt released the Governor of Migori but denied the bodyguard and the driver bail and bond. The Court of Appeal was very clear. Your Honor, I have it here. Michael Juma Oyamo, that is, Your Honor, Criminal Appeal number 113 of 2018. The two bodyguards, Michael Juma Oyamo and Kaspal Ojuang Obiero, were denied bail just because they were police officers. The court in that matter, three-bench judge, Justice Warsame, the President of the Supreme Court of Appeal, Justice Musinga, and the late Justice Professor Otieno Dek, may God rest his soul in eternal peace, was very categorical that the court should impose conditions. And the conditions the court is aware about the court said in this matter that you can, Your Honor, put conditions. None of these people come from Maimayu. They are there because they are working as police officers. They can be ordered to go to their rural homes. They can be ordered to report every week to the investigating officer. They can be reported to deposit their passports, but none of them, they are police constables who has a passport. That is the Court of Appeal saying that release them, put conditions, the parents are here, the wives are here, the children are here, they can stand surety. Your Honor, in summary, there is no compelling reason to grant another 1 hour behind bars for this. May the court find favor in my submission.
10 days ago, for purposes of custodial orders,
the Independent Policing Oversight Authority with jurisdiction to deal with police officers who allegedly have misused their guns. This is a constitutional provision and a statutory provision. So counsel cannot tell the court that they have learned that issue now. The DPP in his circulars to the IG is express. And therefore, anybody purporting to disregard the DPP's directives intentionally did that so that these young Kenyans could stay in custody for more days. You wanna read that, the mischief in that application today. To Your Honor, it is not my letter that brings to play IPOA. It is the law. You know, what does that imply? You have been told that we did cross-examine an investigating officer. And counsel is alluding to relying on the notice of motion and the affidavits in opposition. The question I put to the court is that notice of motion a document for court records? It is sworn by a DCI. And they are all my friends. The police officers are my friends. But in this matter, that affidavit must be expunged from the record. Only an affidavit by an investigator from IPOA can be considered by this court. Only an investigator from IPOA can take the doc and explain why he has not finished with the investigation. To Your Honor, your learned colleague, CM Lorot, listened to those averments. And made a decision granting the state 10 days. You cannot be made an appellate court over a decision that your brother has made of 10 days. And there is no affidavit in this matter from IPOA asking for 14 days. I cannot cross-examine my brother here or my sister. They are not investigators. You know, on the second limb of my submissions, the DPP himself has called for this file. Under Article 157, the DPP cannot be directed by anybody. The questions arising, Your Honor, is this is an officer with delegated authority from the DPP making this application. the Director of Public Prosecution is a serious bureaucracy. How certain is the court going to be that the director can take 14 days to charge or not to charge? There's a possibility that file can stay for 1 year at the office of the Director of Public Prosecution. Not my colleagues here can even attempt to call the DPP and ask him, can you make that decision? What will be the consequences to these young Kenyans who are here? You know, you have been told that these police officers have a lot of influence. For record purposes, these are mere constables. Serious people with serious influences have been released on bond and on cash bail. None other than those even who have been charged for genocide. Being a head of state of Kenya and a deputy head of state were released on bond. So you honor this story of the state condemning police officers just because they are police officers should end. Everybody is equal before this court of law. You know, the state is now alluding to a new argument that the people who are supposed to be witnesses have not been traced. They want 14 days to trace them. They are admitting they don't know who they are tracing. If they are tracing Danstan Omari, then they will be saying his office is in Nairobi. We are going to look for him. You know, there is no compelling reason to extend 14 days. In the first application by the DCI, which I've said should not form part of record, they wanted 21 days. The learned magistrate gave them 10. Procedurally, they have got to come and show what they have done with those 10 days. The respondents are wards of this court. They are detained courtesy of a court order. The court deserves to be told what have they done. You know, a blanket application here founded not on any basis to extend 14 days. Liberty is so sacrosanct for these young Kenyans who work to keep us safe from thugs and and any form means of insecurity in this country. Your Honor, that you are presiding over this matter, it is my submission that they be released on bond or reasonable cash bail, and you impose conditions. They have their family members, they are full here, their wives, their children, and their parents, who will stand surety for them. Your Honor, the blame will go not to the state. The public will get mad with the judiciary for keeping people without charging them. The reason why the framers of the Constitution put an independent judiciary is to stop the excesses of the state. If the state had its way, these police officers could be detained for 1 year without appearing in court. But Kenyans spoke loudly and created an independent judiciary. But only compelling reasons can make these people to be detained far. You know, let the state not entrap the judiciary the way it did in the famous Shakahola matter, where a miscellaneous application detained somebody for 9 months before the state could make a decision to charge. And the blame went to the judiciary, not the state. You know, there's no further compelling reasons that has been provided to continue detaining these respondents unless the IPOA, if they are here, takes the dog and explain what they have done or what they have not done. Kenyans are paid heavily to fund IPOA. Article 10 of the Constitution demands accountability. They come and account to this court. Your Honor, in summary, we make a final submission that the state has completely failed to justify an extension of a further 14 days, because originally it was 21. It was reduced to 10. Now they want 14. That will be a total of 24 days locking these young people. May the court find favor. You know, in a similar matter by Oscar Sudi, the court will have a look at the Oscar Sudi matter. That's Criminal Revision number 208 of 2020. Oscar Sudi Kipchumba versus the Republic, that's the National Cohesion and Integration Commission. Those arguments were brought against Oscar Sudi. Justice Professor Ngugi, then sitting in Nakuru, developed a free test. Then the judge's view, in paragraph 32, the learned judge, the court will look at it. Having reached here in my analysis, the result appears eminently tautological. The application herein largely succeeds. There are no compelling reasons for the continued pre-charge detention of the applicant, or the concerns raised by the state can be accommodated without the very radical measure sought and granted to the state to hold the applicant pre-charge for 11 days in the circumstances of this case. I must return to the words I stated in Joseph Thiongo case, Supra. You know, these are the words that are loudly being said by Kenyans. I'm obliged to observe that the pathway to peace and justice chosen by our Constitution is one that assumes that aggrandizing personal autonomy and liberties, especially in the context of criminal trial, is one that ensures our optimum aggregate collective peace, security and justice more than the alternative path that limits individual liberties in order to safeguard these important values and outcomes. Your Honor, here the judge says, ours is a constitution that wisely assumes that peace, security and justice can be achieved in the context of the rule of law. For this to happen, each of the actors in the governance, law, order and security sector must play their rightful role in ensuring sustainable peace and prosperity. What is the judge saying? That the police are paid to do their job. The advocates who have been paid to do our job. And the judiciary must do their job. Kenya is not a banana country where we are being told that these people can misbehave and they can't be apprehended. We cannot keep people behind bars because we fear that they are likely to interfere with witnesses. Your Honor, and the judge finally said the applicable test is the least intrusive. That is not to deter them. Oscar Suri, a very influential figure in the Republic of Kenya, was released on Kashmir.
I have considered the submissions of the learned counsel for the suspects and equally the prosecution counsels. The counsel for the suspects has submitted and seeks for expulsion of an affidavit forming part of the record. The same affidavit is the same preferred by the prosecution, and it forms part of the basis of the ruling that was rendered by my brother, Honorable Lord, on 31st of October 2025. I am persuaded that the court has no jurisdiction to exercise those orders, but only the court that dealt with that specific affidavit and gave that ruling. So on account of that, and taking into consideration the urgency of the matter, I do direct that the matter be placed before my brother, Honorable Rod, on the 25th of November 2025, based on the urgency of this matter. But until then, the suspects to be held in custody until the 25th of November, and PO to issue.
Magistrate.